Hi, I'm the business guy. So how do you protect your assets from lawsuits and gain financial privacy to keep legal predators from taking your money? Time and time again, an offshore limited liability company, LLC, has proven to be an effective asset protection instrument. Here we will compare two of the very strongest in the world, the Cook Islands LLC and the Nevis LLC. Establishing an offshore LLC can be a very important component of your asset protection plan, and this is because an offshore LLC can help you create a nearly impenetrable layer of security for yourself and your assets. The Cook Islands LLC and the Nevis LLC are two offshore asset protection instruments that offer some of the strongest defense against legal claims, and this is especially the case when placed inside of an offshore asset protection trust. Now, both countries have strengthened their asset protection legislation. Cook Islands did so in 2009. They enacted the Cook Islands International Limited Liability Company Act, and Nevis did so as well when it updated the 1995 statutes. This includes its Nevis LLC Ordinance Amendment 2015 as well as 2017. Now, both countries allow foreign citizens to be members, and you can be a member of this channel for free by subscribing below if you haven't already. And if you could please click the like button below so YouTube promotes it, I'd really appreciate it. Now, here's where the Nevis and Cook Islands LLC are similar. The operating agreements are similar. Neither country recognizes foreign judgments. Plus, the names of the members and managers are not in the public records. So there's very little to differentiate one LLC from the other in these respects. And that is because both countries regularly revise trust and LLC legislation. They each want to closely capture and reflect the prevalent business and legal environment at the current time. Now, there are differences between the Cook Islands LLC and the Nevis LLC with respect to the strength of its asset protection. The charging order limitation is one example that we'll discuss. Both, however, do have specific and strongly worded asset protection legislation, and they strictly enforce it. An LLC can help you build a wall around the assets that you place inside of the company. Thus, you help safeguard those assets from lawsuits. First, the LLC can give you asset protection for the assets you hold in the LLC. That is, the LLC laws can protect those assets inside of your offshore LLC. It protects them against those who may bring lawsuits against you personally. Plus, it can protect you personally when somebody sues your LLC. That is, the LLC provides a barrier that protects you from business lawsuits. Now, these two countries in particular have specifically formulated their laws to help create a safe haven for assets. In addition, when somebody brings a lawsuit to their shores, they have laws that are very friendly to people who have judgments against them. Now, both locations permit the establishment of single-member LLCs. And at the same time, neither impose limits on the number of LLC members. So any number of members may comprise the LLC established on their friendly shores. Cook Islands and Nevis LLC owners can also participate in the management of the LLC, and they can do so without personally being liable for the debts or obligations that the LLC may incur in the normal course of business. And they can also elect to have the LLC managed by non-members. For example, a non-member manager may have a particular experience in the business arena where they operate, or that non-member manager may want control but no ownership. To enhance an LLC's asset protection features, our attorneys may recommend a non-member foreign director should manage the LLC. In this instance, we're talking about a registered trust company or law firm. Such an entity must be a resident of either Cook Islands or Nevis. A foreign LLC manager is not subject to the laws of a member's home country. Therefore, they do not have a legal obligation to follow a court order coming from another jurisdiction. And this is an option to the LLC members in both countries. It's an additional asset protection measure. But the law does not require this in order to have a legally established and recognized LLC. The structure of a Cook Islands LLC is highly flexible, and this of course holds true for Nevis as well. The operating agreement can include any type of code of conduct, member responsibilities, or regulations that are legal. That is, it can include any provision that members wish to include as long as these provisions are legal. It can also omit those they specifically prefer to leave out. That being said, an operating agreement should be drafted professionally. There are too many variables that a person not in the profession can modify that could hamper or eliminate the LLC's protection. Each location has certain statutory provisions in place for the protection of the members. So within wide legal boundaries, members can structure the LLC to suit and serve the purpose for which they're forming the LLC in the first place. This flexibility only adds to the benefits of operating an LLC in either location. There's an additional benefit an offshore LLC offers in addition to being an effective instrument for asset protection. It gives members the highly prized commodity in this increasingly wired, bordering on intrusive world, privacy. Establishing an LLC in Nevis does not require the public filing of members' names nor any other information about them. Your registered agent through our organization can handle future changes regarding membership or assets. The same is true for establishing a Cook Islands LLC. Members are free to run their LLC whether directly themselves or through intermediaries without unwarranted scrutiny. This blanket of privacy also means it is highly unlikely that a creditor will find out the member's connection with an offshore LLC. That is, of course, outside of formal discovery. Members can keep their company records anywhere in the world where they judge the records will be most secure. Neither jurisdiction requires an annual inspection of accounts or records. Now keep in mind that the U.S. and many countries tax worldwide income even if it's inside of a company. So you want to be sure to keep tax compliant. We help handle renewals of the LLCs on the islands each year, and this includes the renewal of the registered agent. It also includes the payment of the annual government renewal fee. And in this heavily interconnected world, it may seem that a person's digital footprint is a mere click of a mouse away, and it can be accessed by just about anybody who has access to the internet and used in litigation. With an offshore LLC in either island paradise, you essentially do not leave readily apparent digital footprints. You don't leave your assets out on the open for anybody to trace. You also enjoy a level of privacy that's tough to achieve anywhere else. Okay, charging order protection, and this is a big one. Cook Islands and Nevis generally only recognize one lawful avenue of remediation against an LLC. The only remedy is what the LLC law calls a charging order. However, both countries strictly define the limitations and scope of a charging order. That is, they specifically define what they allow a creditor to collect from an LLC debtor member. And we talk more about this below. Naturally, one must properly establish the LLC within the proper jurisdiction. First, the charging order only covers the member's percentage of ownership interest. It could only theoretically access those assets that would normally have been distributed to that debtor member, if any. It does not affect the assets of the other LLC members, nor the distributions that are due to the other members. Second, a creditor with a charging order against a debtor member cannot assume or take over that member's position in the LLC, nor can the creditor interfere with the running of the LLC in any manner. In fact, charging order notwithstanding, a debtor member can continue operating the business. The member can carry out his or her duties and responsibilities as prescribed by the LLC regulations, and they can do so without interference from the creditor. A charging order does not give a creditor any power or right to liquidate or seize the assets of an LLC. That is, it does not allow the creditor to seize the LLC assets in order to satisfy the debt of a member. It does not restrict the business of the LLC in any particular manner. The LLC can continue to function with its assets intact and the distributions to the other members unaffected. Okay, let's compare the Nevis LLC versus the Cook Islands LLC for charging order expiration. Now, the third point here is that both countries severely limit a charging order to the actual amount that is owed by the debtor member. Punitive, retributory, or an exemplary damage is not permissible. In this regard, a Nevis LLC has a slight advantage over the Cook Islands LLC. That is, the Nevis LLC legislation places a strict 3-year expiration limit on the charging order. Currently, Cook Islands LLCs have a limit of 5 years on the effectivity of charging orders. So Nevis LLCs, a 3-year expiration on charging orders. Cook Islands LLC, a 5-year expiration on charging orders. Advantage, Nevis. Nevis and Cook Islands are both sovereign countries. As such, each have their own set of rules and regulations governing LLCs. They hold them above the laws of other countries, and rightfully so. Neither country will automatically enforce a judgment issued by a foreign court against a debtor member. In fact, Nevis laws dictate that a creditor must mount a lawsuit against a debtor member in a Nevis court. The Nevis LLC regulations required the creditors to pay a sum of $100,000 to a Nevis court before any action can be brought against a debtor member of a Nevis LLC. In 2018, the $100,000 limit was done away with. Now, Nevis courts can impose a higher bond amount if they see fit, or less for that matter. The Cook Islands does not mandate a similar deposit, although a court may request one to be made at the start of the trial. So in Nevis LLC, a creditor must pay a court deposit to initiate a lawsuit, for example, $100,000 or more. With the Cook Islands LLC, the deposit is not mandated to initiate a lawsuit. Advantage, Nevis. Nevis and Cook Islands make it easy for members to transfer their existing LLC to or from almost any country in the world. In the Cook Islands in particular, all it takes is a simple application process, so it's quite easy to re-domicile a foreign LLC to the islands. Just give us a call and we can take care of that for you. So what we do is we complete an application form, then we include copies of the existing LLC certificate of formation and organizational documents. We submit them for filing, and when they are accepted, the LLC is recognized to be valid. In fact, it will be established on the islands retroactively from the date it was originally set up in the other jurisdiction. Nevis has an equally simple LLC migration regulation in place. Now, it's also important to note that the wording of the Nevis and Cook Islands legislation regarding LLC migration is very specific when it talks about debts and obligations. An LLC takes with it all debts and obligations, including any judgment against it wherever it goes. And as stated, the islands will dutifully protect any LLC that has been properly set up according to Nevis and the Cook Islands laws. However, they will not set aside an already existing judgment against the LLC at the time of its migration to the islands. So if your company already has a judgment, form a new Nevis or Cook Islands LLC and then transfer the assets from that company into the new one. And that strategy offers a better solution. So form a new LLC if the existing company already has legal issues. Now, if the statutes were changed in Nevis or LLC, such as the immigrant LLC shed its prior liability, the pendulum would swing wildly in the favor of that jurisdiction. But so far, that's not the case. In the final analysis, the decision to establish an LLC in the Cook Islands or Nevis will have to take a few things into consideration. Not only should you consider each country's existing LLC laws, which are clear and comprehensive, but also other asset protection instruments that are available to you, such as an asset protection trust. In addition to their well-respected LLC statutes, each of these countries also possess asset protection trust statutes that are superior to other jurisdictions. An LLC established in either country offers comparable levels of protection for claims against its members. Both have exceptional asset protection statutes and offer flexibility in the structure of the operating agreement. In addition, both regions are independent sovereign countries, so they offer further protection to LLC members because they are less susceptible to outside pressures. And as stated, they do not automatically enforce foreign judgments, so the matter would first be subject to the veracity of their own laws. Both countries accept charging orders as the only remediation against a debtor member of an LLC that has been properly established under their jurisdiction. Moreover, both also severely limit the scope of a charging order. Nevis has a slightly shorter period of time when it will consider a charging order to be effective. As we stated, it is 3 years in Nevis when compared to the Cook Islands at 5 years. Suffice it to say, both offshore locations provide clear and comprehensive asset protection laws that are strictly enforced in their respective jurisdictions. This benefit also offers a collective sigh of relief to LLC owners and members everywhere. Whereas LLC laws are constantly improving as of this writing, the Nevis LLC has the slight advantage over the Cook Islands LLC. Please click like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy.